Florida's housing market isn't just struggling, it's in free fall, and the laws making it worse are already in effect. If you're a renter, your landlord can raise your rent with almost no legal limits. If you own a condo, you just got hit with special assessments that could cost tens of thousands of dollars. If you're a homeowner, your insurance premiums tripled and your property taxes keep climbing. And if you're an immigrant renting in Florida, new laws are making landlords afraid to rent to you at all. This isn't a prediction. This is happening right now. And I'm going to show you exactly how Florida law is accelerating the collapse. Number one, Florida has no rent control and landlords can raise rent without limits. Florida Statute 83.49 explicitly prohibits local governments from imposing rent control or any ordinance that would limit the amount a landlord can charge for rent. This means there is no legal cap on how much your landlord can increase your rent when your lease ends. If you're paying $1,500 per month right now and your lease expires, your landlord can legally increase it to $2,000, $2,500, or even $3,000 per month. The only requirement under Florida law is that the landlord must provide proper notice before the rent increase takes effect. Under Chapter 83, if you have a month-to-month lease, your landlord must give you at least 15 days written notice before increasing rent. If you have a lease longer than month-to-month, the rent can only be increased when the lease term ends. But the landlord can choose not to renew and offer a new lease at whatever price they want. There's no restriction on the percentage of increase. This has created a crisis across Florida where renters are seeing 30, 40, even 50% rent increases in a single year. In cities like Miami, Orlando, and Tampa, median rents have increased by over 35% since 2021. And tenants have no legal recourse. You either pay the new amount or you move out. The problem is that moving out doesn't help because rental prices are high everywhere in Florida. Families who have lived in the same apartment for years are being priced out of their homes. And because Florida law favors landlords so heavily, there's no protection for tenants who can't afford these sudden increases. If you can't pay the new rent, your landlord can simply choose not to renew your lease and you have to leave. The combination of no rent control and Florida's strong property rights for landlords has created an environment where housing affordability has collapsed for working class and middle class renters. Number two, condo owners are facing massive special assessments due to new reserve requirements. After the tragic Surfside condominium collapse in June 2021, which killed 98 people, the Florida legislature passed sweeping reforms to condominium safety regulations. These changes, codified in Florida Statute 718.112, now require condominium associations to conduct structural integrity reserve studies and maintain adequate reserves for major repairs. Previously, condo associations could waive reserve requirements with the vote from owners, which meant many buildings operated with minimal reserves. That's no longer allowed for structural components. Starting December 31, 2024, condominium buildings 3 stories or higher that are 30 years old or older must have milestone structural inspections conducted by licensed engineers and architects. These inspections identify necessary repairs to the building's structural integrity, and the association must then fund those repairs through reserves. The financial impact on condo owners has been catastrophic. Associations that previously had little to no reserves are now required to collect massive amounts of money in a short period. Special assessments of $20,000, $50,000, even $100,000 per unit are being levied on owners who thought they were investing in affordable housing. These aren't optional fees. Under Florida law, if you own a condo unit, you are legally obligated to pay all assessments levied by the association. If you refuse or can't pay, the association can place a lien on your unit under Florida Statute 718.116 and eventually foreclose on your property. Owners who bought condos as retirement homes or rental investments are now faced with impossible choices. Pay assessments they can't afford, sell at a loss in a flooded market where everyone else is also trying to sell, or face foreclosure. The ripple effect is that condo prices are plummeting because buyers know they'll inherit these massive assessment obligations. Buildings that were worth $300,000 per unit 2 years ago are now struggling to sell for $150,000 because potential buyers see the reserve studies showing millions of dollars in needed repairs. Number three, homeowners' insurance crisis is making properties uninsurable and unsellable. Florida is experiencing a homeowners' insurance crisis that's making property ownership financially unsustainable for many residents. Private insurance companies have been fleeing the Florida market due to increased hurricane risk, rising construction costs, and litigation expenses related to claims. Between 2020 and 2023, at least 6 major insurance companies operating in Florida either went insolvent or withdrew from the market entirely. This has forced hundreds of thousands of homeowners into Citizens Property Insurance Corporation, which is Florida's state-run insurer of last resort. Citizens was designed to be a temporary safety net, but it now covers over 1.3 million policies. The problem is that Citizens premiums are significantly higher than what private insurers used to charge, and they're increasing every year. Homeowners who were paying $1,800 annually for insurance are now paying $4,000, $6,000 or more. For waterfront properties or homes in high-risk coastal areas, annual premiums can exceed $10,000. Under Florida law, if you have a mortgage, you're required to maintain homeowners insurance. If you can't get insurance or can't afford the premiums, you're in default on your mortgage, which can lead to foreclosure. Even if you own your home outright, going without insurance is an enormous financial risk because a single hurricane or fire could destroy your entire investment with no compensation. The insurance crisis is also affecting home sales because mortgage lenders require proof of insurance before closing. If a buyer can't obtain affordable insurance, they can't complete the purchase, which means properties are sitting on the market longer or selling at reduced prices. Some sellers are offering to pay a year or two of insurance premiums just to close deals. The situation is unsustainable and there's no clear solution on the horizon because the underlying risk factors haven't changed. Florida remains highly exposed to hurricanes and flooding, construction costs remain elevated, and insurance companies have no financial incentive to return to such a risky market. Number 4, property taxes are rising due to increased assessments and millage rates. Florida property taxes are based on the assessed value of your property multiplied by the millage rate set by local governments. While Florida has a constitutional provision called the Save Our Homes cap, which limits annual increases in assessed value to 3% for homesteaded properties, this protection doesn't apply to new buyers, non-homesteaded properties, or rental properties. When you purchase a new home in Florida, the property is reassessed at the purchase price, which in today's market is often significantly higher than the previous assessment. If you buy a house for $400,000 that was previously assessed at $250,000, your tax bill immediately jumps to reflect the new value. For properties without homestead exemption, including investment properties and second homes, there's no cap on annual assessment increases. This means rental property owners are seeing massive tax increases, which they're passing on to tenants through higher rents. Additionally, local governments across Florida have been increasing millage rates to fund services, infrastructure, and public safety. Even with the Save Our Homes cap protecting some homeowners from assessment increases, higher millage rates still result in higher tax bills. School districts, counties, and municipalities all set their own millage rates, and the cumulative effect can be substantial. Property owners who thought they could predict their annual expenses are finding that tax bills are becoming unpredictable and unaffordable. The combination of rising property values, increased assessments for new purchases, and higher millage rates means that housing costs in Florida are spiraling upward at every level. This affects both owners and renters because every cost increase for property owners gets passed down through higher rents and purchase prices. Number 5, eviction process in Florida favors landlords and happens extremely fast. Florida Statute 8356 through 83625 governs the eviction process, and it's designed to move quickly in favor of landlords. If you fail to pay rent on time, your landlord can serve you with a 3-day notice to pay rent or vacate. This notice gives you exactly 3 days, not including weekends and holidays, to pay all rent owed or move out. If you don't comply within 3 days, the landlord can immediately file an eviction lawsuit in county court. Once the lawsuit is filed, you typically have 5 business days to file a written response. If you don't file a response, the landlord wins by default and gets a judgment for possession, meaning you must leave. Even if you do file a response, eviction hearings are usually scheduled within 2 to 3 weeks. Florida judges handle eviction cases rapidly, and unless you have a very strong legal defense, the landlord will win the case. Once the landlord has a judgment for possession, the court issues a writ of possession, and the county sheriff physically removes you from the property. From the initial 3-day notice to being physically removed can be as little as 3 to 4 weeks. This speed leaves tenants with very little time to find new housing, gather moving resources, or resolve financial problems. What makes Florida's eviction process particularly harsh is that there are very few valid defenses. If you didn't pay rent, the fact that your landlord failed to make repairs or violated other lease terms generally doesn't provide a defense to non-payment. You have to pay rent even if the property has significant habitability issues. Your only option is to pay the rent and then pursue a separate legal action for the landlord's violations, which most tenants can't afford to do. The eviction record itself creates long-term housing problems. Once you have an eviction on your record, future landlords can see it during background checks, and most will refuse to rent to you. This creates a cycle where one missed rent payment can lead to permanent housing instability. Number 6, security deposit laws provide some protection but are widely violated. Florida Statute 83.49 governs security deposits and requires landlords to return deposits within 15 days if there are no deductions, or within 30 days if the landlord intends to make deductions. If the landlord wants to claim any portion of your security deposit for damages or unpaid rent, they must send you written notice by certified mail within 30 days of you moving out. This notice must state the landlord's intention to impose a claim on the deposit and the reasons for it. You then have 15 days to object in writing. If you don't object, the landlord can deduct the claimed amounts. If you do object, the landlord must either return the disputed amount or file a lawsuit within 60 days. The law also requires landlords to hold security deposits in a separate account and pay interest if the deposit is held for more than 1 year. However, these protections are routinely violated, and tenants often don't know their rights. Landlords frequently keep entire security deposits, claiming excessive damages or cleaning costs that aren't legitimate. Because the amounts involved are typically between $1,000 and $3,000, most tenants don't hire attorneys to fight for their deposits. Small claims court is an option, but it requires time, filing fees, and knowledge of the legal process that many people don't have. What's particularly frustrating is that Florida law allows landlords to claim a wide range of deductions from security deposits, including damage beyond normal wear and tear, unpaid rent, unpaid utilities, and cleaning costs. The definition of normal wear and tear versus damage is subjective, which gives landlords significant leeway. A landlord might claim that carpet stains require replacement and deduct $1,500 from your deposit, even though the carpet was already worn when you moved in. Unless you documented the condition of the property with photos and written reports at move-in, you have little evidence to dispute the claim. Number 7, SB 1718, immigration enforcement is creating fear and housing instability. As covered in previous content, Senate Bill 1718, which went into effect July 1, 2023, has had significant impacts on Florida's housing market beyond just immigration enforcement. The provision, making it a felony to knowingly harbor undocumented immigrants, has made landlords extremely cautious about who they rent to. While the law doesn't explicitly require landlords to verify immigration status for all tenants, the threat of felony charges has created a chilling effect. Landlords are now asking for more documentation during the application process, and many are implementing informal policies to screen out applicants they suspect might be undocumented. This has led to discrimination against Hispanic tenants, foreign-born tenants, and anyone with an accent or foreign-sounding name. Even legal residents and U.S. citizens are being subjected to additional scrutiny if they fit certain ethnic profiles. The law has also affected mixed status families where some members are citizens or legal residents and others are undocumented. Families are afraid to list all household members on lease applications because doing so might expose undocumented family members to detection. But failing to disclose all occupants can be grounds for eviction if the landlord later discovers unauthorized occupants. The housing instability created by SB 1718 goes beyond individual cases. Entire immigrant communities are experiencing increased fear and reduced housing options. Some landlords in areas with large immigrant populations have seen vacancies increase as families leave Florida for states with less aggressive immigration enforcement. This has created localized rental market disruptions where some landlords can't find tenants, while other areas have severe housing shortages. The law has also affected employers who provide housing to agricultural workers and other employees, creating labor shortages in industries that depend on immigrant workers. Number 8, code enforcement actions can result in property condemnation and displacement. Florida counties and municipalities have code enforcement departments responsible for ensuring properties meet minimum housing standards. These standards are typically based on the Florida Building Code and local ordinances covering structural integrity, electrical systems, plumbing, sanitation, and safety. When a property fails to meet code requirements, the local government can issue violation notices requiring the property owner to make repairs within a specified time frame. If the owner doesn't comply, the government can impose fines, place liens on the property, and in severe cases condemn the property as uninhabitable. For tenants, code enforcement actions can be a double-edged sword. If your rental unit has serious habitability issues like mold, broken plumbing, or electrical hazards, you can report these to code enforcement, and they'll inspect the property and require repairs. However, if the violations are severe enough that the property is condemned, you'll be forced to vacate immediately, often with little notice and no assistance in finding alternative housing. Florida law doesn't require local governments to provide relocation assistance to displaced tenants, except in very limited circumstances. Property owners facing code enforcement actions often choose to evict tenants rather than make expensive repairs. This is particularly common with older rental properties where bringing the building up to current code standards would cost more than the property's worth. The owner might decide to demolish the building, sell the land, or simply abandon the property, leaving tenants to find housing on short notice. Code enforcement has become more aggressive in Florida following high-profile building collapses and safety incidents. After the Surfside tragedy, local governments across the state increased inspections of older buildings, which has resulted in thousands of violation notices and condemnation orders. Tenants living in older affordable housing are disproportionately affected because these are the buildings most likely to have code violations. When these buildings are condemned or demolished, the affordable housing stock shrinks, and displaced tenants have to compete for increasingly scarce and expensive rental units. Number 9, homeowners associations and condo associations have extensive legal powers. Florida statutes Chapter 720, homeowners associations, and 718, condominiums, grant these associations significant legal authority over property owners. If you buy a home in a community governed by an HOA or purchase a condo unit, you're automatically subject to the association's governing documents, which include the Declaration of Covenants, bylaws, and rules and regulations. These documents can impose restrictions on how you use your property, what modifications you can make, what colors you can paint your house, whether you can rent your unit, and numerous other aspects of property ownership. Associations have the power to levy assessments, which are mandatory fees that all owners must pay. If you fail to pay assessments, the association can place a lien on your property under Florida Statute 720.3085 and 718.116. These liens take priority over most other debts, including mortgages in some cases. If you continue to refuse payment, the association can foreclose on your property to collect the debt. Associations can also impose fines for rule violations, typically up to $100 per violation, with a cap of $1,000 for continuing violations. The enforcement process allows associations to hold hearings, determine violations, and impose penalties without court involvement. Property owners who disagree with fines or other association actions must either comply or file a lawsuit, which is expensive and time-consuming. Many associations have become increasingly aggressive in enforcement, imposing fines for minor infractions like parking violations, unapproved landscaping, or leaving garbage cans visible. The cumulative financial burden of assessments, fines, and legal fees can make homeownership in HOA and condo communities unaffordable. Additionally, associations can amend their governing documents to impose new restrictions or increase fees, and individual owners have limited ability to prevent these changes. While owners can vote on some issues, the voting structure often favors developer control or allows a simple majority to impose significant financial obligations on all owners. Number 10, landlord retaliation is illegal but difficult to prove. Florida Statute 8364 prohibits landlords from retaliating against tenants who exercise their legal rights, such as complaining to government agencies about code violations, organizing tenant associations, or testifying in court against the landlord. Prohibited retaliatory actions include increasing rent, decreasing services, threatening eviction, or actually evicting a tenant in response to protected activity. If retaliation occurs within 90 days of the tenant's protected activity, Florida law presumes the landlord's action was retaliatory. However, the landlord can overcome this presumption by showing a legitimate, non-retaliatory reason for their action. The problem is that proving retaliation is extremely difficult in practice. Landlords can almost always identify some non-retaliatory justification for their actions. If you complain to code enforcement about mold in your apartment and your landlord raises your rent 2 months later, the landlord can claim the increase was due to market conditions or increased operating costs. Unless you have clear evidence, like emails or text messages where the landlord explicitly states they're raising rent because you complained, you'll struggle to prove retaliation. Even if you do prove retaliation and win a lawsuit, the remedies under Florida law are limited. The court can order the landlord to stop the retaliatory conduct and may award you damages. But you still have to continue living in a rental relationship with a landlord who has already demonstrated hostility toward you. Most tenants choose not to pursue legal action even when they know they're being retaliated against because the practical risks outweigh the potential benefits. If you sue your landlord for retaliation, they may choose not to renew your lease when it expires, leaving you to find new housing anyway. The power imbalance between landlords and tenants in Florida is severe, and the legal protections against retaliation don't adequately address this reality. Tenants who assert their rights risk housing instability, and most decide that staying quiet and enduring problems is safer than speaking up and facing eviction. If you made it through this entire breakdown, you now understand why Florida's housing market is collapsing from multiple directions at once. These aren't theoretical problems or future predictions. These are active laws and real situations affecting millions of Florida residents right now. Whether you're a renter watching your monthly costs spiral out of control, a condo owner facing special assessments you can't afford, or a homeowner drowning in insurance premiums and property taxes, you need to understand the legal framework that's creating this crisis. Hit that like button if this opened your eyes to what's really happening. Subscribe because I'll keep breaking down Florida laws that directly impact your housing and financial security. Drop a comment. Are you dealing with any of these issues right now? What's your rent increase been like? Share this with anyone who needs to understand why housing in Florida has become unsustainable. Stay informed, and I'll see you next time.